Yes.
My Lords, before I move on to my next topic, I just want to do two things. First, I think I omitted to show you a bit of the transcript, and particularly the bit that the judge relies on. And secondly, then I'll show you what the judge said. So if we could go back to the supplementary bundle at page 116.3. On page 42, as I showed you, the foot of page 42, line 13, I had asked him, he said if the bank claims any one item, from what you're saying, thinks of what he's been deprived of, not lost profits, not expense, then it is, as I've said, it is the way how the bank decides it should be remedied. Then it's hard to say that, as a matter of fact, the bank is not remedied in restitution. Yes, sorry, we got confused. The purpose of the question of his lordship's, and he interrupted that it was limited in tort. Yes, in tort. So then we need to just pick it up at the top of the next page. So now that we've seen actually what the true debate here appears to be, where we have two void loans, as I've discussed, A and B, and a payment has been made in respect of the liabilities relating to one of them, your evidence is, you say it's for the creditor to choose what liability is in fact he going to treat being discharged by the payment, correct? Says, yes, that's correct. My evidence is not tied to your factual situation. The creditor made willful decision to accept. Yes, it refers to the situation when the creditor was taking money for 2 times beyond his will, and he did not agree to any repayment willfully. I said, I think you're straying into the facts. Do you agree this? Our case, as you know, is concerned with what we've called the relevant drawdowns. I asked him if he was familiar with that. He said, yes. And then we have repayments, as you know, by later loans, some of them called intermediary loans, some of them are relevant loans, and we also have assets. We'll come to assets in a moment. Now, where there has been a repayment, what you've told us is it's for the creditor to make a choice. I think you were a moment ago, that choice I think you were saying a moment ago, isn't it? It might not be a genuine choice being made if the people who make the choice are the people who themselves are responsible for the taking of the loans, correct? It may be so. But I think you would agree, wouldn't you, that it's a question of fact as to whether the creditor or the bank has made a choice. That's right, isn't it? And then he says it's definitely not a question for Ukrainian law expert. No, it's a question of fact. But I think what you would agree, it's a question of fact whether the bank, whether via its old management or via its new management, has made a choice. Such a choice, that's the question of fact the court would have to determine. It's a question of fact, I agree. Again, I said it's all a question of fact. He said yes. If the facts show the creditor has in fact made its choice, so it has chosen in fact that on my example, the $1 million that came in should be treated as crediting against the liability of borrower A, for instance. If it does that, it can't then ignore that and say, well, actually, although I credited borrower A's liability, I now want to sue the tortfeasor in respect of loan A, because it's too late, isn't it? Once you've made that choice, any loss in respect of loan A has been extinguished. And this was next his critical answer. Mr. Howard, I believe it's a matter of fact to decide, but as we discussed before, if the borrower A made it explicit that it was his intention to treat repayment for the fraudulent loan A in such a way, I believe it would be difficult for him to sue for the same loan in the court if he accepts, on some factual patterns, that this is actually discharge of his claim in tort which he had. The bank, you mean if the bank has done that, so if the bank has treated the payment as discharging the liability of a borrower in respect of loan A, he couldn't then come along and either sue that borrower in respect of loan A or sue the party who procured it, claiming the loss because there is no loss. again, you know, if you please, be more clear what you refer to the loss, because you know I said we've 3 items of loss. Yes, the loss in category 1, and his answer was the loss in category 1, yes. Now, when one reads that exchange, on one view, what Mr. Beketov was saying was that if you have chosen to accept the repayment to discharge the restitutionary liability, then you no longer have could claim in tort against the person who procured it. Now, another view of this is that he was saying, no, you had to do 2 things. You had to both accept the repayment as discharge of the restitutionary obligation, and you had to accept it as discharging the claim in tort. And the ambiguity crept in on page 45 at line 11 to 12, where in answer to my question, he referred to if he accepts on some factual patterns, this is actually discharge of his claim in tort. Although when you look at what he said in answer to my question at lines 13 to 23, he appeared to be accepting actually it was sufficient that you accepted it in discharge of the restitutionary liability. Now, the way in which the judge interpreted his evidence, just as what it was he was saying, you'll see at page 400 of the core bundle at paragraph 1081 of the judgment. Where he says, in my judgment, the essential substance of Mr. Beketov's evidence on the effect of the repayments on the bank's claim under Article 1166, in which the relevant loans were void, was as follows. In each instance, I accept this evidence reflects the law of Ukraine. Whether the source of what was said to be a repayment was an intermediary drawdown made under a relevant loan or an intermediary loan, or the value of a transferred asset, or one of the new loans issued as part of the transformation, it will not serve to reduce or extinguish the bank's claim in tort if it was improperly paid out of the bank's own resources. The mere choice by the bank to treat what is said to be a repayment of a void loan as a discharge of the borrower's restitutionary liability in relation to that loan does not in and of itself extinguish the bank's claim in tort against the third party for the loss sustained in the amount of the loan. The position may be different if the bank chooses or consents to the use of what is said to be a repayment as a discharge of its claim in tort. And when you see that, and you see how Mr. Beketov's evidence actually evolved, we would suggest that even if the judge is right to say that out of what was said in this tail end of his cross-examination does amount to what is on 1081, it was somewhat equivocal, somewhat confused, and in any event, we say the judge was wrong to find it represented Ukrainian law on the basis of this evidence, and the court can and should overturn that finding. Now, that then takes me to my next topic, which is I can deal with briefly at this stage, the principles on which...
Well, can I just distinguish those 2 questions? Because I understand your submission about the effect of the evidence and your criticisms of the judge's analysis of it. But you seemed, in what you've just said, to be making a distinct point Because you said, in any event, he's wrong to say it represents Ukrainian law.
Yeah.
That's the bit I'm struggling to understand, because we have someone who is an expert in Ukrainian law giving us his opinion as to what a Ukrainian law court will decide. Why is that not Ukrainian law? I mean, it might be different, of course, if you had a Ukrainian authority to show us that was to the contrary effect, or you had more compelling evidence from an opposing expert. But as I understand it, you don't have any Ukrainian authority to show us, and you're not making the submission that Mr. Alyoshin's evidence was more cogent and should have been preferred.
Well, I'm going to make some submissions about Mr. Alyoshin's evidence in a moment. At the moment, I was just looking at what Mr. Beketov's evidence was. But in answer to your lordship's...
Can I rephrase my question in this way?
Yeah.
Perhaps make myself a little more clearer. Let it be assumed for present purposes that 101 represents findings the judge was entitled to make as to the effect overall of Mr. Beketov's evidence.
Yes.
I understood you to be making a submission that nevertheless that didn't represent Ukrainian law. And it's that part of the submission that I'm trying to understand.
Yes, but I'm grateful. 1081.
Yes.
Yeah. The submission that I make is that the two distinctions aren't there? There's a question of what is the correct interpretation of what Mr. Beketov actually said. So assuming Mr. Beketov actually read properly, said what the judge says at 1081, the question is, what we say is, when you look at the evidence as a whole from Mr. Beketov and and what it's based on, that it doesn't make any sense, and it's that if one were analysing, and I'm going to come on to that, as to what Ukrainian law was, based upon Mr. Beketov and some unchallenged evidence of Mr. Alyoshin, and particularly the fact that they were relying on the Yurov decision, and that there are no decisions of the Ukrainian court, so that what you're dealing with is matters of just really general principle. In our submission, the court was in as good a position as Mr. Beketov, and this court is in as good a position to ascertain what the answer is as a matter of Ukrainian law. That what you have here, in other words, simply having somebody who says, well, I'm a Ukrainian lawyer, and I say this is the position under Ukrainian law, when it's not based upon anything more than either his assertion of that fact, or insofar as it does refer to an underlying principle, that is just a general principle of reasonableness and justice and things like that, then it doesn't take the matter any further, and the court, this court, or the judge at first instance in this court, is in a gooder position to assess what the position is.
Is that right? I mean, if the question is this good court in as good a position to decide what is just, then the answer, one would hope, would be no, but that isn't the question, isn't it? Because the question is, what would a Ukrainian court decide, or to be more accurate, the apex court in Ukraine decide, applying principles of Ukrainian law?
Yes. But what I'm saying is, if you look at what I've shown you what Mr. Beketov said and how this evolved, and the principle that he had put forward in his reports was actually not the principle ultimately that he was putting forward. And so so you'll remember the principle in his reports is that if you have one unlawful loan repaid, or wrongful loan repaid out of another the proceeds of another wrongful loan, then that doesn't reduce the loss for the purposes of a claim in tort. Now, by the time he came to give evidence, he departs from that principle. So we saw that in relation to a valid but wrongful loan. He accepts there is no such principle and a repayment is effective. So you're then left with the question of whether what he then said about a void loan, whether any of it, whether you can rely on it as encompassing any principle. Because all that you've got is, if one thinks about it, is his assertion that a void loan is different and that discharge of the restitutionary obligation isn't sufficient to extinguish the claim in tort. There's no, as it were, underlying analysis as to why a restitutionary liability is any different to a contractual liability. It's just something that emerged in this unsatisfactory way towards the end of his cross-examination, and in fact in a rather equivocal way. So it's not entirely clear even that what he was saying. But even if you accept that he is saying what the judge says...
Yes, but the point of my question is to try and differentiate two things. I mean, you first of all make a submission to the effect that, and this is a paraphrase,
yeah,
what the judge says in paragraph 18081
yes,
doesn't accurately reflect the witness's evidence. Now, if you're right about that, one needs to acquire no further. But what I'm interested in is the question of, well, what if you're wrong about that?
yeah.
Suppose that was, at any rate, an available reading of the witness's evidence. So the judge was entitled to make that finding as to what the witness's evidence was.
Yes. Then...
Do you then have an independent basis for saying, nevertheless, that's not Ukrainian law?
Well, my lord, that's what I'm going to come on to. We say we can challenge that as a finding of fact as to what Ukrainian law is. And
all right, well, I will wait and see how you develop that. Thank you.
Yeah, but we're going to come to various reasons why we say that the judge was wrong. What I wanted to show your lordship is that the basis on which 1081, even if one says this was an available, a possible interpretation of the evidence of Mr. Beketov, that one sees it's arisen in this very confused way. So even just taking it as a statement, his statement as to what he thinks, what you find is it arose after he had substantially shifted his evidence already and just really emerged in the course of this cross-examination. Now, can I come back to that in a moment, why we say the judge shouldn't have accepted that? But because your lordship's question also touches upon the court's approach to foreign law. And I mean, the principles are well known and set out in the Lopag decision in the Privy Council, which is well, we've quoted it in paragraph 16 of our skeleton, and it's in the authorities bundle at tab 50, page 2485. I don't think, unless your lordships want to, we need to turn it up. But the overarching principle is that with any appeal on foreign law, there is a spectrum of cases where the willingness of the court to intervene is dependent mainly on the extent to which the judge has been able to bring to bear his knowledge and skill in analysing English law. So the more a judgment involves applying principles that are similar to English law, principles or means of legal analysis which are analogous to English law reasoning, the more the court may be prepared to scrutinise the judgment and overturn it. So But it equally means that if the judge's skill and experience in analysing English law are essentially irrelevant and turns on an assessment of expert evidence that's alien and difficult to have any instinctive feel for, then the judge's findings are closer to factual findings and the court less likely to be willing to intervene. Now, all of that is a general rule, and as Lord Hodge said in the Perry case, there will be cases where an appellate court does consider itself able to review the findings of a trial judge on a civil system of law. It depends on the nature of the error and the circumstances in which it arose. Now, we submit that this is one of the cases where the court can properly review the cogency of the judge's findings as to the effect of repayments. It's not a case where a high degree of deference to the judge's findings is appropriate or necessary. Firstly, it is true, of course, that Ukraine, or the Ukrainian law, is a civil law system and therefore different from the common law. It's codified and doesn't have the same system of precedent. But the judge's decision on this issue didn't actually turn on an analysis of actual, subject to one authority I'll have to come to, which the judge referred to, but it didn't turn on an analysis of any actual Ukrainian legal materials. There were no issues of statutory interpretation that bore on the question, no court decisions subject to this one that the judge referred to. Mr. Beketov's opinion was avowedly based on what he called first principles. And the only principles of Ukrainian law that he cited were, first, the principle that loss is subject to full compensation, and secondly, the principle of justice, fairness, and reasonableness, to which I'll come back to, but they're not alien concepts. What is more, the most relevant authorities in this area are the two English authorities, Yurov, which was expressly referred to, and which itself is based on the Kolomoisky case. Mr. Beketov, willingly, having been shown the Yurov case, adopted and agreed it represented Ukrainian law. So, self-evidently, the proper analysis of those authorities is something that this court is perfectly well placed to consider. And all of that is before we take into account the extraordinary delay that occurred in this case in producing the judgment. That was a factor which was expressly noted by Lord Justice Lewison when he gave permission at tab 23, page 894. But Mr. Beketov's evidence was given between the 9th and 11th of October 2023, and the judgment was handed down at the end of July of last year, between 21 and 22 months later. Now, a delay of itself does not mean that there is a basis for setting aside the judgment. However, as was said in the Bilter case, a delay is an important factor to be taken into account when considering the trial judge's findings and treatment of evidence, and that the appellate court must exercise special care in reviewing the evidence, the judge's treatment of the evidence, his findings of fact and his reasoning. We set that out at paragraph 9 of our skeleton. Now, in this case, nearly 2 years after the evidence was given, no one could have a detailed or reliable recollection of the evidence being given at the time, and necessarily any assessment is based on reviewing and re-reviewing the written submissions and the transcripts. This court and the judge are in effectively the same position. And in our submission, the court is not just entitled, but obliged to review his findings and his reasoning with great care. Now, turning to why we say the judge was wrong, why we say that the findings at paragraph 1081 are wrong and cannot stand. There are 5 points, 5 headings that we would make for this. The first is the inherent implausibility of the position. The second is absence of evidence in support. The third is ignoring unchallenged evidence to the contrary. The fourth is ignoring the relevant authorities, particularly Eurov. And finally, that the reasons for agreeing with Mr. Beketov are faulty. So taking the first, and standing back, the position which Mr. Beketov ended up adopting, and which the judge accepted as correct, is on its face a bizarre one. It means that there is a critical difference between a situation where the first loan is valid and a situation where it is void. If the first loan is valid, a repayment by the borrower extinguishes both the borrower's liability and the tortious loss. But if the loan is void, a repayment by the borrower or intended borrower may extinguish the borrower's liability, but it doesn't extinguish the tortious loss unless the bank specifically elects to accept the payment as discharging the tortfeasor. Now, it's fair to ask, what possibly could be the justification for that distinction? Mr. Beketov, in his written evidence, didn't suggest there was any justification for treating void and valid loans differently, or in his oral evidence. To the contrary, for most of his evidence, he suggested there was no distinction between the two. Neither did the judge identify any rationale for this distinction. And in our submission, it would be an entirely arbitrary rule. That being the case, we suggest the judge should have been much more cautious about it as accepting it as representing Ukrainian law. Now, just pause for a moment and think about this. The loans in this case were found to be void because they contravened various statutory provisions. But often a loan which is procured by a fraud of some kind will not be void. It may be voidable. Why should a repayment in that scenario have a different effect from a repayment of the relevant loans in this case? We would suggest it's difficult, if not impossible, to see any logical justification. Equally, a loan may be void without any fraud taking place at all. Again, in this case, the loans, another reason for the loans being void was they didn't have the necessary corporate approvals. Now, on the judge's findings, a loss resulting from a loan which didn't have the necessary corporate approvals and was therefore void by statute would not be affected by a repayment unless also there was a waiver of any tort. Whereas a loss resulting from a loan that was induced by negligence or even by fraud, if the loan wasn't void, would be extinguished. And again, we say that doesn't make sense. So what is the touchstone of whether repayments reduce tortious loss in a void loan scenario? Now, according to the judge, it is where the funds that are used to make the repayment were, 1081, subparagraph 1, last bit, improperly paid out of the bank's own resources. But one has to think about that for a moment. How does that work in practice? Once the money has gone to borrower number 2, it's no longer the bank's money, it's the borrower's money, and I'll show your lordship where the judge said that. So to apply this test, you potentially have to trace money that comes in backwards. It might be through a chain of transactions to determine whether the money ultimately was paid out of the bank's own resources, and then decide whether the payment was improper. That is doubly problematic. In the first place, although in this case the repayments did more or less directly come from the bank, in many cases they will not, and it would be necessary to undertake a more complicated tracing exercise to decide whether they originated with the bank or not. What is more, even where the immediate source of repayment was the bank accepts that the analysis doesn't stop there, and on its approach, it's necessary to identify the ultimate source of repayment. That's why its experts did the exercise to identify not just how the relevant drawdowns were repaid, but also how the intermediary loans were repaid and the extent to which repayments had been made under the new loans. So there are potentially unlimited chains of transactions upstream and downstream of the drawdowns in question that you need to investigate if you're going to decide whether a repayment is of the type which reduces the loss arising from the drawdowns or not. And that is reminiscent of the exercise that Mr. Justice Toulson referred to in Kolomoisky Bank, of saying it would be like entering a jungle without a map. Now, secondly, what is actually meant on the judge's approach as improperly paid out of the bank's own resources? I drew your attention at day 27, page 111, to the exchange where, sorry, I'll just give you the reference to it. It's 112. Yeah, it's 112.2 of the supplementary bundle, where Mr. Beketov said under Ukrainian law, we do not have wrong or imprudent debts. We only have valid or void contractual obligations. In other words, there is no concept of improper payment in Ukrainian law. So the judge's summary doesn't actually accurately reflect Mr. Beketov's evidence. And it's actually a position that we would suggest couldn't represent Ukrainian law. And even if it could, it's very implausible that whether a claimant has suffered loss or not should depend on whether or not the funds coming, repaying the restitutionary obligation have been obtained properly or improperly. So we say that the principle the judge has arrived at is peculiar and implausible on its face. The second point is the absence of evidence in support. And now, of course, sometimes an English court might be driven to accept that a foreign law contains a particular rule, even if it seems strange, arbitrary, or illogical to us. But we would suggest that would require clear and cogent evidence before doing so. And the evidence before the judge was very far from meeting that description. First, as we've already discussed, the evidence from Mr. Beketov on this specific issue was unsatisfactory and equivocal. We've already seen the various twists and turns that it underwent. Even his oral evidence was internally inconsistent and contradictory. He first said the principle that he espoused applied to all loans, then immediately conceded it didn't apply to valid loans, but without ever articulating a reason for that. Then he conceded it for void loans as well, before changing his position on that, and then in re-examination tried to reverse his position on valid loans. So it was all very far from clear or consistent. But secondly, even leaving aside all the inconsistencies and contradictions, there was never anything of substance underpinning Mr. Beketov's evidence. He accepted there was no Ukrainian case law, and his opinions were, we suggest, mere ipse dixit. The only principle he did cite in support was the principle that loss must be fully compensated. And the bank places a lot of weight on that phrase, full compensation, but they place more weight on it than it can possibly bear. Full compensation simply means restitutio in integrum. That's the phrase the judge used at 952, no more and no less. As a remedy for tort, it can be contrasted with a contractual claim where the amount of compensation may depend on the terms of the contract. It certainly doesn't mean that the court has to lean in favour of a claimant in assessing compensation, still less overcompensate the claimant beyond the loss actually arising from the unlawful act sued upon. And there were no Ukrainian authorities were cited which suggested anything of the sort. Now, I'll come back to full compensation again in a moment, but at the moment I'm just addressing the fact that Mr. Beketov's opinion had no proper theoretical or empirical underpinning. And it was either ipse dixit, or even if not quite that, unsupported by anything of substance and therefore of little evidential value. Now that's so much for Mr. Beketov at this stage, but there was evidence on this point from Mr. Alyoshin, Mr. Kolomoisky's expert, and this is at SB, supplemental bundle, at page 46. And the first, if your lordships look at paragraph 30, this is where, as you can see, he's addressing repayments, and he refers to what Mr. Beketov said, and he quotes, and then he says about 6 lines down, I noted in my first report, it was at that stage unclear whether the bank's position was that the purported repayments were invalid for all purposes, or whether it accepted the repayments were valid as between the bank and the borrower, but nevertheless such payments fell to be ignored when determining the extent of the defendant's tortious liability. Mr. Beketov's report's done little to clarify the point. In any case, I remain of the view that neither argument is valid. And then at 31, he refers to what Mr. Beketov said about no rule of Ukrainian law obliging the victim to sue in respect of one misappropriation rather than the other. And Mr. Alyoshin says, while it's correct the victim of 2 unlawful acts may choose to sue in respect of one of them only, if he does so, he can only recover the loss caused by that unlawful act. He cannot recover damages for loss caused by a different unlawful act, for which he has not asserted a claim. And he then refers to an authority. I don't need to detain you on that, but the paragraph 35 is then important. And at paragraphs 35 to 38, Mr. Alyoshin addresses the Yurov case. And in our submission, this was important evidence about Yurov. So, because what you'll find here is that, that the experts both considered Yurov was compelling and instructive as to Ukrainian law. So you'll see at 35, here he's addressing first the repayment defense. And he says in the second sentence, having referred to Mr. Beketov citing Yurov, I agree the analysis in that case is compelling and supports Mr. Beketov's opinion that the use to which any relevant, with which I agree, the use to which any relevant loans were put is not relevant when determining the amount of the loss. However, Mr. Beketov omits to note that the reasoning in Yurov is completely inconsistent with his approach to the present issue. That's to say, whether the loss caused by the relevant loans is reduced or extinguished to the extent that the relevant loans or restitutionary liabilities arising out of such loans have themselves been reduced or extinguished. And at 36, he explains that, as he understands Yurov, the main defendants contended, well, you can see what he says, what they were contending, and Mr. Justice Bryant said that was wrong in principle. Then at 37, he notes that Mr. Beketov omits to quote the immediate following part of the judgment. And you'll remember that, which is the part where Mr. Justice Bryan says that it's looking at net loss and that it's a fallacy and sleight of hand because it's a different loss caused by a different event. And at paragraph 38, he says, this reasoning is entirely consistent with Ukrainian law and entirely inconsistent with and destructive of Mr. Beketov's argument. Expressly confirms that the loss caused by an illegitimately obtained loan is a different loss caused by a different event from the pre-existing loss due to an earlier loan, and that to assess the lender's loss by reference to its net financial position, rather than by considering each loan separately, is wrong, as it involves a fallacy and sleight of hand. I agree with all of this. It follows inescapably that where a defendant wrongfully procures two loans, 1 and 2, a tort claim brought in respect of loan 1, which has been repaid in full, is bound to fail because the original loss resulting from loan 1 is extinguished and a new and distinct loss resulting from loan 2 arises. Now, in other words, what you have there is Mr. Alyoshin addressing Yurov and addressing the points that we submit come out of Yurov. And if you're saying Yurov represents Ukrainian law, these are very relevant points. Now, the judge didn't find Mr. Alyoshin to be a satisfactory witness, but undoubtedly this was highly relevant evidence on the most critical issue in the case, and it was not challenged. That's despite Mr. Alyoshin being cross-examined for in excess, I think, of 2 days. Now, in our submission, it's clear as a matter of law that a party has to challenge evidence if it wants to invite the judge to reject it. That principle was reaffirmed by the Supreme Court in Griffiths and TUI in the authorities at tab 51, page 2526 at paragraph 42. Now, Mr. Alyoshin had given this evidence and the bank had not challenged it. And in our submission, that provides further reason why the judge was not justified in accepting what Mr. Beketov ended up saying as representing Ukrainian law. Still less, where the judge failed to deal with the point which both Mr. Alyoshin was making and we made by way of submissions by reference to what came out of the Yurov case. The judge didn't, and I'll come back to this point, the judge didn't address in his judgment Yurov in the context of the repayment defense. And when this was pointed out to him at the consequentials, you'll see he brushed the point aside. But what one had was, so there was Mr. Alyoshin explaining what he drew from Yurov and how that would apply in Ukraine. On the other hand, you had Mr. Beketov, who'd performed U-turn after U-turn, and finally arriving at an inherently implausible position for which he had no Ukrainian sources, and where actually there was expert evidence supporting a different view, which stood unchallenged. Now, there's another aspect of the judge's consideration of this which I should draw attention to, which we submit is unsatisfactory, and that is if you go in the judgment to paragraph 953, the judge at this stage is dealing with full compensation in this section, and he hasn't got into the detail of the repayment defendants. But what you can see is the judge, if you look at what he says at 953, he says, the bank submitted and I accept in approaching that question, a Ukrainian court will be guided not just by the clear meaning of the phrase full compensation, but also the associated principles of general application, justice, good faith, reasonableness, and protecting a victim's rights. He says, Mr. Alyoshin didn't really address this aspect of the test, but looked at overall, I think it's clear that when working out full compensation, courts required to make a factual assessment, taking what Mr. Hunter called a real-world view, looking at the substance. This means, taken together with the burden of proof, the defendants must prove that what they did provided real benefit to the bank, sufficient to amount to full or partial compensation for the extraction of money pursuant to the relevant drawdowns. In other words, the question is whether, as a matter of substance and reality, the defendants are able to establish that compensation for the harm caused by the relevant drawdowns has been provided to the bank. In answering that question, the court's required to consider whether the bank has received such sum of money as is required to make it whole and put it fully back in the position it would have been in but for the wrongdoing. Now, the difficulty with this is the judge has already reached the conclusion that whether a repayment reduces the bank's loss by reference to, here I'll call it the first drawdown, depends on whether the bank is left in a better position overall following the further drawdown and the repayment, as opposed to what is the loss arising from the particular relevant drawdown. And he bases that interim conclusion on what he says is the clear meaning of the phrase full compensation and the general principles of justice, reasonableness, and so on. But it's on that basis, and only on that basis, that the bank is able to argue that Mr. Beketov's evidence amounted to more than just an ipse dixit. That's in their skeleton at paragraph 90. But that's unsatisfactory for two reasons. First, those extremely broad and general principles don't advance the analysis of the particular issue we are concerned with. Already touched on full compensation. It just means loss has to be compensated. It doesn't begin to answer the issue with which we're confronted in this case as to whether a loss has been extinguished by a repayment. Similarly, appeals to general notions of justice, reasonableness, and so on don't take the analysis anywhere. To say that an argument should succeed because it's consistent with a principle of justice and reasonableness without more is simply begging the question. There's no obvious reason why it's more just or more reasonable to allow a party to sue in tort on a loan that has been repaid as opposed to a loan that hasn't been repaid, particularly when the only reason for doing that is to be able to sue in an unnatural foreign forum. And if one wants to make an argument that this is more just or reasonable in an approach, we would suggest one has to support it with actual reasons, not just assert it. Now, secondly, the judge said that Mr. Alyoshin did not really address this aspect of the test, and so went on to adopt the bank's submissions. That, unfortunately, is simply wrong. Mr. Alyoshin did addressed these points squarely in response to Mr. Beketov's evidence. And you see that in his supplemental report, which is in the supplementary bundle at page 43.01. And he addressed this at paragraph 18. He said that they all agreed that harm is an element of a tortious claim. But there was no disagreement about how you determine the existence and amount of recoverable harm. And then at paragraphs 20 on page 4302 to paragraph 24, he addressed the principles which the judge said he hadn't addressed. So at 20, he's addressing the, he said that the identification and quantification of harm are governed by express statutory rules, disagreed with Mr. Beketov, who was the view that courts can determine the amount of harm based on general principles of reasonableness, good faith, or fairness. He said that's incorrect. He's not aware of any cases where the courts have applied solely the general principles such as reasonableness, good faith, or fairness to determine the amount of non-contractual damages. Mr. Beketov doesn't cite any, and there are specific rules regarding causation and assessment of damages. And while those rules are naturally informed by concepts of fairness and reasonableness, such concepts have no independent application, can't be invoked directly to increase or decrease the amount of compensation. Then at 21, he refers to the principle of full compensation, and having referred to what Mr. Beketov says at 22 on the next page, he says, explains that full compensation is not an autonomous or overriding principle. And then at 23, he explains that, and 24, that the principle of full compensation only means that you're entitled to recover damages to the extent of the loss. So this was contrary evidence which the judge appears to have overlooked. Judging on what he said, he clearly did overlook it, saying that Mr. Alyoshin didn't address this. Now, so the next point we make, which we've already touched upon, is the judge's approach to the authorities, and particularly to Yurov, on which both Ukrainian experts had relied. As I've already said, Yurov is an English authority, albeit it's dealing with analogous provisions in Russian law, but both experts cited it as reflecting Ukrainian law, and it's, in our submission, highly relevant because it, and the case to which it referred, Kolomoisky, states in terms, but Yurov states in terms, that the repayment of a loan, albeit by a subsequent fraudulent drawdown of another loan, extinguishes the tortious loss in respect of the first loan. Now, despite that and our submissions of its relevance, despite Mr. Alyoshin's evidence, the judge didn't engage with Yurov at all in this context. Now, I've already addressed the suggestions made by the bank that Yurov is distinguishable because it dealt with valid loans or because the claim was for unpaid balance of loans as opposed to the amounts of drawdowns, less repayments, distinctions without a difference. But these were not points made by the judge, and they're bad points in any event. Now, the judge did address Yurov in his consequentials judgment. And you'll see that at page 705. At paragraph 132, and this is, with the greatest respect, simply brushing the point aside. So at 132, the second sentence, I also do not think it is arguable that Yurov provides an answer to the bank's case, because it was different on this point from the present case, being concerned with an outstanding debt owed by a borrower, not loss caused by a void transaction by which money was misappropriated. So in his very lengthy judgment, and then in the consequentials, this sentence is the extent to which the Yurov case and the submissions that we made and Mr. Alyoshin made about it were dealt with. And with respect, it is not an adequate response. The distinction he's drawing is not a valid one. There was an outstanding debt owed by the borrower in this case. The fact that it was owed in restitution rather than contract can't make any difference. Neither can the fact that the bank chose to frame the claim in terms of money drawn down less recognised payments as opposed to the unpaid balance of the loans make any difference. There's no conceptual or economic difference. But more importantly, he hasn't engaged with the principle that Mr. Justice Bryan was dealing with in Yurov, when he and Mr. Justice Tolson was dealing with in Komachini. And as I say, you find that actually dealt with in the extract I showed you in Mr. Alyoshin's report, and indeed we dealt with it in our written submissions as well. So the omission to analyse what are the only authorities either side found that bear on this issue, we would respectfully suggest, is a serious omission, and one which does require, in fairness and justice, this court to step in and conduct its own analysis. Now, what were the other reasons that the judge gave for agreeing with Mr. Beketov's ultimate position? Well, I'll look at them, but none of them was sound. The first point that the judge said, and you see this at 1065, and 1070, it was that the repayment defence was unprincipled because it assumed that the bank's loss was coterminous with the liability of the borrower under the loan. Now, with respect, that is misconceived. The repayment defence makes no such assumption. You may remember, because I showed you in cross-examination, of course, there was the evidence of Mr. Beketov that where there was a wrongful drawdown, you could potentially have three types of loss: the loss of the capital, loss of expenses, and loss of profits. Now, if you repaid the capital, that wouldn't extinguish the loss in respect of loss of expenses and loss of profit, and no one has ever suggested it would. So if you did have such a claim, it's only the loss in respect of your loss of capital that one is saying has been extinguished. In other words, it operates pro tanto, as you would expect. Now, it's also the case that there may be circumstances where the liability of the borrower is extinguished, written off, or settled without the tortious loss necessarily being reduced. And it's not our case that every time the borrower's liability is, for instance, written off or settled, that would necessarily reduce the tortious loss. But that simply never arose in our case. That wasn't an issue. Our case is simply concerned with a repayment, and in our submission, that self-evidently, if there has been a repayment, must reduce the extent of the loss to the extent of the payment, and the English authorities entirely support that. So the judge's point here is based upon a misunderstanding of the repayment defence. Our defence is and only has been that the loss is reduced to the extent that there are repayments, not that termination of the borrower's liability in and of itself necessarily extinguishes the loss. Now, the other point is, although the Ukrainian experts agreed there were no authorities in Ukraine on the point, the judge, for his part, decided there was. And the judge decided that he could derive support, even though this isn't what even Mr. Beketov said, from a Ukrainian case called Yukub Spilka. And that he referred to at 1071. Now, amongst other places, he'd also referred to it earlier. Now, the case is in the bundle at supplementary bundle at page 54. It was a claim, and you can take this from paragraph 951 of the judgment here, where the judge summarised what the case was about. It's at 951, and it was a claim by the liquidator of a bank against officials of the bank who'd entered into high-risk bond purchases that led to the bank's insolvency. And the defendants argued that the bank had failed to mitigate its loss by bringing claims against the counterparties to the transactions. But the Supreme Court of Ukraine held that claiming against the counterparties wouldn't make any material difference to the shortfall, and so couldn't excuse the defendants from liability. And going back to the supplementary bundle at where it starts at paragraph page 54, at page 72, the relevant part is under the heading regarding the defendant's arguments about the connection between the actions of the funds or its authorised persons to liquidate the bank and the amount of damage caused. The court cites Article 1193, which is the rule on contributory negligence, and then the relevant parts of the judgment are at 770 on the next page to 7.70 to 7.72, and there is nothing in this case and in these paragraphs which is inconsistent with the repayment defence. The point that they were talking about here went to liability, not quantum. And if the liquidators had sued the counterparties and made a recovery, that plainly would have reduced the amount recoverable from the defendants in tort. But that wasn't what the argument was about. The what the court was saying, it would not have reduced the liability so significantly as to afford a complete defence. So the learned judge, this case was cited before him for a different purpose, and then he has misapplied it and misunderstood it in the context of the repayment defence. Now, the next point that the judge made at 1066 is the point that there were no repayments in fact. And the way the judge puts it in the last part of that paragraph is that the individual defendants have not established that what they characterise as repayments were anything other than steps to cover up what had gone before, nor that the bank has received any genuine value by way of compensation. And he says something similar at 1072. Now, I'm obviously going to have to address under my next heading whether there were repayments. Obviously, if there weren't repayments, then the repayment defence doesn't get off the ground. But if there were repayments, the motive for making them or the mechanism by which they were made is neither here nor there. Ultimately, the judge's essential point and the bank's essential argument is that you have to stand back and look at the whole course of events, and that a loss cannot be considered to have been extinguished if repayments are made using the proceeds of another fraud on the bank. And he says that in terms at 1072 in the last sentence. And he finds similar references at 953 and in the consequentials judgment at 131. Now, what the judge was doing here, although he denied it, was being misled by precisely the fallacy and sleight of hand identified by Mr. Justice Bryan in Euro. It confuses the loss deriving from the relevant drawdowns only, and stopping there, that is all that the bank has sued in this jurisdiction on. It's confusing that with the ultimate overall or net loss that the combination of relevant drawdowns, intermediary and new loans has caused. Or putting it more simply, it confuses the loss deriving from the relevant drawdowns with the different loss deriving from the intermediary and new loans. And as Mr. Justice Bryan correctly put it, those give rise to a different loss caused by a different event. The original loss deriving from the relevant drawdowns was extinguished by the repayment, if there was a repayment, and as Mr. Justice Toulson put it, whatever the derivation of the funds may have been. Putting it on the judge's own terms, or putting it in the judge's own terms, the repayments themselves did provide real benefit to the bank. They involved the borrowers paying their own money to the bank, because the money that the borrowers drew down was in Ukrainian laws theirs. It only becomes possible to say there was no real benefit, or that the bank was not fully compensated, if you zoom out and take into account the fact that the funds which the borrowers used to make the repayments had been taken from the bank under another misappropriation, and the fact that those separately misappropriated funds have not been repaid. That is what is meant when it is said the bank is still left with a loss. As the judge put it at 1086, in perhaps a revealing part of the judgment on this point, in the penultimate, or the one but penultimate sentence, he says, it still has a worthless fraudulent loan on its books. So it does, but it's a different fraudulent loan and a different loss. The bank was free to claim for that loss by bringing a claim for or including that loss caused by the subsequent misappropriation. But it has chosen not to do that. It's chosen to limit its claim to the relevant loss and the loss caused by the relevant drawdowns alone. And in our submission, that loss has been extinguished to the extent of the repayments. And since there is no longer any loss, there is no entitlement to further or full compensation or indeed any compensation. So, my lords, that takes me to the question of whether there was actually a repayment. Now, I'm dealing here with what have been called cash repayments. I'll deal separately with the asset transfers as my last topic. Now, we would respectfully suggest that there is a degree of confusion in the judgment, particularly between paragraphs 1083 and 1095, about what this issue amounts to and what our case is. Now, at times, the judge appears to have thought that we had somehow, for our case, adopted Mr. Beketov's evidence, or the judge's interpretation of his evidence, and that the bank needed to have made a deliberate election to abandon any tortious claims in order for the tortious loss to be extinguished, and that we were saying that the bank had made such a choice. Now, if he did understand us to be saying that, then his view that a new case might have needed to be pleaded and explored in the evidence would have been understandable. But that was never our case. Our case has always been simply that if there was a repayment of the borrower's liabilities, and we said there was, that repayment necessarily and automatically extinguished the tortious loss. So the only question, if we are right on the correct legal approach, was whether in fact there had been repayment of the relevant borrower's liabilities. Now, I've shown you Mr. Beketov's evidence on this. You will recall that in his written evidence, he did not address repayment as such, beyond his glib assertion that if the relevant loans were void, there could be no contractual repayment. In other words, he did not address the position of discharge of a restitutionary obligation. His evidence, which didn't appear anywhere in his reports and was said for the first time in cross-examination, was that whether the borrower's restitutionary liabilities were repaid depended on how the bank chose to treat the payments it received. If it chose to allocate the payments to the borrower's liabilities, then the borrower's liabilities were repaid. If it chose to allocate them to some other debt, then the borrower's liabilities were not repaid. And if we just break that down as to how that applies here, assume that there is a relevant loan which has a liability created a liability in a borrower of $1 million in restitution, and assume a new borrower borrows $1 million, and that $1 million then gets paid to the relevant borrower who pays it back to the bank. Now, one can see that the bank could say, I'm not going to treat that $1 million as going to the relevant borrower's liability. I'm going to treat it as going to the new borrower's liability. One can see that where they both have liabilities in restitution, that may be a position it can adopt. But in this case, where it has chosen to treat the payment as going to the relevant borrower, then our submission is and was that that it constitutes a repayment and is effective. But because this question of choice as to which liability you were treating, which restitutionary liability you were treating the payment applying to, it was for that reason that we said in our closing submissions, paragraph 98, which is in the supplementary bundle at 171, that we said that the vital question was whether the bank had made a choice to allocate the repayments to the liability of the relevant borrowers as opposed to any other liabilities. And we said the answer to that was self-evidently yes. Now the judge said at 1087 that this was a substantial shift in our case, saying that choice entered into the equation for the first time. And he then said, and this was a complete misunderstanding of the position, at 1088, that made it clear, he said, it was no longer Mr. Kolomoisky's case, that where the loan was void, repayment automatically extinguished any liability in tort for harm caused by the original transfer. And with respect, that was wrong and a misunderstanding. We were still saying, as we've said throughout, that repayment, that is repayment by the borrower of its debt or discharge of its obligation in restitution, automatically extinguished any liability in tort for having procured the drawdown. The reference to the...
I'm a bit puzzled by this. I think we need to see the passage that's quoted in 1087 in context. I appreciate your trying not to go to unnecessary documents, and that's very laudable. But I think in this instance, we need to see the quotation in context if you're going to make a point.
Yeah.
So I think you said it was 171, is that right?
It is... Yeah, it is page 171. What?
Doesn't seem to be a quote from 98.
My Lord, I think the correct reference is page 148. It's paragraph 50, subparagraph 2 of my learned friend's written closing at trial. So 51, brackets 2.
No, I don't think so. The reference I wanted is at page 171, paragraph 98.
Well, it may be so, but I was looking for the source of the quotation.
Oh, I see.
Mr. Howard is correct. The source of the quotation is paragraph 51.
Sorry, I apologise. I was focusing on my own. Yeah. That's fine. Paragraph 51, I was going to come on to explain the confusion that has arisen. And just while we've got...
Well, I'm a bit puzzled at the moment.
Yeah.
Because you seem to have said in the written closing submissions below that it's not automatically extinguished. And you say the judge is wrong to have taken that at face value. I'm struggling to understand why.
Well, no, because there are two under. What we were saying at 51(1) is, so with a valid loan, the way Ukrainian law works, you have a contractual liability to repay, and when you pay, if you send in the money, that automatically extinguishes the payment.
To be sure, but we're interested in the void.
My Lord, just explaining the distinction. Now, what we're referring to at 51(2), or at least it may, what we were intending to make clear, is that by simply handing over the money, that does not automatically at that point discharge the restitutionary liability, because it's up to the recipient whether it treats it as a repayment of the restitutionary liability or some other liability. And so it's not
okay, fine, but as you say here, it's a question of fact as to what choice has been made.
Yeah.
And that seems to be the point that's then reiterated at paragraph 98.
Yes. Yes.
So it's a factual question as to what choice the bank has made.
Yes.
And that still seems to me to be rather different to automatic discharge.
Well,
or automatic extinction.
Well, so the point I'm making is this, my Lord. In a contract, if I can just contrast the two situations, in a contractual setting, the debtor can force the bank's hand because he says, this is repayment of that loan, pursuant to my contractual obligation. In a restitutionary sense, the person handing over the money can't force the bank's hand, because if there is more than one liability, the bank can choose which liability it's going to treat the payment in respect of. So in that sense, it has a choice. So it's not automatic in the sense by tendering the money that you have automatically caused the restitutionary liability to terminate. But if the bank has chosen to take the money to, in our case, to discharge a liability in respect of a relevant loan, in other words, it has credited the account, then that automatically extinguishes both the liability in restitution and the tortious liability. In other words, there are two automatics that one needs to separate out. Perhaps I haven't expressed it very clearly. One is whether you have repaid the restitutionary debt. And you don't have a right, if you have more than one restitutionary debt, to say which one it is that the money is to go to. But once the bank has accepted the money, for instance, for a relevant loan, we say that then has the effect, by reason of that, of automatically, or it has the effect of discharging the liability on the restitutionary obligation, as well as, therefore, the liability in tort. In other words, the choice, this is the important case, that the choice case that we are making is only relevant to whether the borrower's liability in restitution is repaid, not to the question of liability of the procurer, the wrongful party, in tort. If the restitutionary liability is discharged, that then does discharge the liability in tort. So our case throughout was that there were payments of money back to the bank. Secondly, the bank had credited those sums towards the relevant borrower's liabilities. 3, the borrower's liabilities in respect of those loans had therefore been extinguished or reduced. Therefore, the tortious loss occasioned by the relevant loans had also been reduced. And that was our case, and that's how the judge understood it. You can see in the judgment at 1043. And you can see at 1043, this is Mr. Kolomoisky's second sentence argument, started from the propositions that the relevant drawdowns involved actual transfers of money by the bank, and that the liabilities under the relevant loans, pursuant to which those relevant drawdowns were made, were extinguished by actual transfers of money back to the bank, whatever the source. He said this was the case whether, irrespective of whether the relevant loans were valid or void, because in any event, if in the event they were valid, any contractual obligation was discharged by repayment. And in the event they were void, any restitutionary obligation was discharged when the bank chose to treat the borrowers as having repaid all they owed. And so that was, in our submission, that was at that paragraph, the judge accurately summarized our case. And the question of choice achieved some prominence in the light of Mr. Beketov's cross-examination and the point that he was making, which was a fair point, which was when the defendants were in charge of the bank, when money came back in as payments, insofar as we were saying, well, the bank has credited the accounts of the relevant borrowers, it would be a fair point for the bank to say, but that was your own conduct. That's when you were in charge of the bank, and you can't rely on it. And so the question of choice simply arose as our saying, well, this is what happened as a matter of fact. All these payments came in and they were credited. But anticipating the point that my learned friends would make, well, any choice that was made while the defendants were there doesn't count. We say, well, actually, though, once nationalisation took place, everybody treated these in exactly the same way. And so the position we got to, and I showed you in Mr. Beketov's evidence, was he agreed that if the bank chose to allocate a payment to the borrower's liability, that would reduce the borrower's liability in restitution. He also agreed at some stages that the borrower's liability, if a borrower's liability was reduced by a repayment, so too was the tortious loss. I showed you he agreed that for both valid and void loans, but then ultimately changed his position for void loans only. And I've submitted why that doesn't make any sense. But the one point that we didn't debate with Mr. Beketov, because it was a question of fact, was the extent to which the bank had in fact chosen to allocate the payments. Now, and he rightly said that was simply a question of fact and not for him. Now, the reason we described it as a key issue in that, not because it was an issue of substance, it was just a step in the analysis of whether there had been repayment, in fact, in respect of these restitutionary obligations. Now, it was never in dispute that the bank had chosen to apply the payments derived from the intermediary and new loans to pay down the balances of the relevant loans, and thereby, we say, to discharge the liabilities of the relevant borrowers. Now, for the judge to find that there were no repayments by the borrowers, or to refuse to find there had been repayments, with respect, is difficult to follow. Now, let's just see what actually happened. So if we take the position at the time of repayments, now there is, as you will have seen, there's a debate about what the bank had actually accepted in its pleadings, and whether the bank had accepted that there were repayments. Now, the judge found at 1038 that it hadn't. Now, the debate actually doesn't matter a great deal because the factual position is clear, but we say the judge was actually wrong in the way he construed the pleadings. You see at 1038, he says that he didn't accept my submission, that what had never been in dispute is that whether the borrower's obligations to repay have been discharged. He then says it's not an issue the bank recorded in its books that the loans had been repaid, and it's also clear the bank challenged the question of whether or not the relevant loans had been repaid, and he said it was careful to use the concept of purported repayments throughout. And then he says the bank never accepted the impact of payment made from monies drawn down under further loans is properly to be characterized as payments. Now, and at 1039, he said, quoted the bit of the pleading in which the bank called the payments purported and said they were made for the purpose of disguising the misappropriation. Now, in order to actually see fairly what the position was, one needs to look at the defense at paragraph 55C, which is in the core bundle at page 820. So that's bundle 4. And so at 55C on page 820, you have Mr. Kolomoisky's primary defense to the claim is that all of the 1.9 billion claimed was repaid, save for $25 million odd dollars. It's denied the bank can ignore repayments funded by intermediary or new loans. Any loss caused by relevant drawdowns has been extinguished to the extent it was repaid. Now, the bank's response to that, sorry to jump around, is in the supplemental bundle at page 85 in their reply. And the relevant part is at page 85 at paragraph 27. And that's where they say that they deny that the drawdowns of 1.91 billion have been the subject of genuine repayment by way of cash repayments. And carrying on, they were procured by D1 and D2 and caused by and or made using funds derived from the intermediary loans. As such, the purported repayments fall to be disregarded and in any event did not in fact reduce the bank's loss. And the judge referred to this form of words, saying at 1040 that made it clear that the repayments weren't properly be characterized as such and did not in any event reduce the bank's loss. And he says the 2 points are separately pleaded and the bank's case is separately articulated. And then at 1041 to 1042, he amplifies that. Now, what the judgment confuses are three distinct questions. The first was, were the loans genuine loans which could be the subject of genuine loan repayments? Secondly, were monies in fact paid to the bank and credited to the borrowers, whether or not that took place under valid loan agreements? And thirdly, did those payments reduce the bank's loss? Now, these are clearly distinct concepts. The fact that the loans were void meant that there were no genuine loans and therefore no genuine repayments of loans. But that doesn't affect the question whether monies were actually paid to the bank or credited to the borrowers in fact. Similarly, whether a payment to the bank and a crediting of the borrower's account occurred is a separate question from whether that payment and credit reduce the tortious loss recoverable from third parties. Now, in our submission, the bank's pleadings, none of the bank's pleadings, amount to a contention that no payments were made to the bank at all. The point that the bank was making was first that there were no genuine loans, the loans were void, and so no repayments of genuine loans. And the second point they were making was that the repayments did not reduce the bank's loss or tortious loss. None of that means that they didn't get payments, that the payments didn't come into the bank, or that the payments were not credited so as to discharge the borrower's debts. The judge was clearly impressed by the fact that the bank's pleading used the phrase purported repayments. He drew attention to that in various paragraphs, including 1038, 1039, and 1040. But that doesn't mean that the borrower's liabilities that arose in restitution were not repaid. But there are a number of reasons for that. First, it doesn't actually make any logical sense at all. If no payments occurred at all, you wouldn't need to ignore them, and there would be no question as to whether they reduced the bank's loss or not. They simply wouldn't have happened, and there'd be nothing to ignore. So by purported, the bank couldn't have been saying that the payments didn't occur. Secondly, we can see from another paragraph of the pleading what the bank actually means by purported, and that's in the supplementary bundle at page 87. At paragraph 27b at the foot of the page, point 4.3, and it says the bank accepts that its loss is reduced if a relevant drawdown was ultimately purportedly repaid from a source which the bank does not allege to be invalid. In other words, whatever the money, wherever it comes from, it is a purported repayment. Even if it were $1 million that came from a separate account of Mr. Kolomoisky, it would still be purported because it is a payment in respect of a void loan. So all purported can mean is that the payment is not actually a repayment under a valid agreement because the agreements are void, but it's not disputing that it's still a real payment and a real payment credited to the borrower and discharging the liability. And similarly, one sees, interestingly, in the same pleading on page 86, in fact, I think it's in the same sub-paragraph, that 27B.A1, where they plead that the intermediary drawdowns were to a very large extent ultimately repaid by the asset transfer and or funds derived from the new loans issued pursuant to the transformation. In other words, they accept that the monies that came from the new loans did repay the intermediary drawdowns. So it's very difficult to see on what basis the new loans are real transactions which do give rise to real movements of money which repay the intermediary drawdowns, but that when you're dealing with the relevant drawdowns, you say something different. So we say the judge was wrong in his analysis of the pleadings, but in any event, it is, we respectfully suggest, incoherent and untenable to contend that no repayments occurred. The use of the word purported can't be relied upon by the judge or with respect to the judge as a sort of magic wand that avoids the need to have regard to the facts. You can't pretend something didn't happen because you label it purported. So let's just see what the position was. First, it's common ground, or was common ground, that the bank's transactional data recorded payments coming into the bank. And it was also common ground that, or at any rate found by the judge, that the same data sources, the same ledger entries, reflected real movements of money from the intermediary and new borrowers to the bank. Now, these concepts can't be separated. In an electronic banking system, the making of a ledger entry recording a credit to one account within a bank and a debit to another account is the making of a payment by one party to another. The ledger entry is not simply how the payment is recorded. It reflects and represents an actual payment that has been made. And that was actually, that's what the judge found, and that was consistent with the evidence of the Ukrainian experts. So if I could ask you to go back to the judgment, and we could go to 1157. This is where the judge is dealing with a submission that was made by Mr. Bogolyubov, dealing with, and you see it starts at page 4112. It's part of the use of funds defense and the bigger, what he calls the bigger fraud argument. And at 1157, the bank submitted that one of the problems with the argument, with the analysis put forward on behalf of Mr. Bogolyubov, was it proceeded on the erroneous basis that relevant drawdowns were just ledger entries involving nothing more than a simple change in name of the borrower. And for that reason, there was no theft from the bank and nothing has been appropriated. The way the point was put by Ms. Montgomery was the relevant drawdowns did not amount to a deprivation of the bank's property giving rise to harm, They were just said to be ledger entries, which created new money in the hands of the borrowers without depriving the bank of any of its money. This was essentially the same point in his answer to the thief in a bank vault analogy.
What's that a reference to? Where do we find a thief in a bank vault?
I'll have to give you the reference. I can't recall offhand. But I agree that this argument cannot be sustained in the light of the agreed expert evidence. While what occurred was undoubtedly the making of a series of ledger entries, the experts agreed the movement of money recorded by ledger entries from the bank account of a customer from the bank to the bank account of a customer is a deprivation of the bank's funds. This was the agreed position because, as the experts said in their joint statement, money, whether in the form of cash or in a bank account, is a form of property, and in appropriate circumstances, and providing all other elements are present, loss of money is actionable under the Ukrainian law of tort. They confirmed it makes no difference to the bank's claim that at all times the monies involved in the misappropriation remained in accounts held at the bank. Mr. Beketov's crisp explanation of the position with which I agree was that an electronic transfer of funds from one person to another is thus capable of constituting harm to the transferor. He went on to explain, by reference to Article 1066, that the funds so transferred become the funds of the customer, with the consequence the bank has no right to determine or control use of funds of the client, and to establish, other than prescribed by the agreement or law, limitation of the client's right to use funds in its own discretion. This is also the case where a bank's money has been transferred to a customer's account pursuant to a void transaction, such as a fraudulent loan agreement. He says, unless the customer agrees it may do so, the bank cannot, at its discretion, transfer those funds out of the customer's account without first obtaining a court judgment entitling it to do so. So you see, the position that is explained here is that it really raises the point that my Lord was asking me about this morning. It's not gold coins as such, but there isn't actually any distinction, certainly from a Ukrainian law point of view, because even where you have a void transaction, the funds that are credited to the account become the customer's, and he's free to deal with them as he pleases. Yeah, the bank vault point, my Lord, is at paragraph 1139.
Thank you.
So the relevant drawdowns undoubtedly involved real transfers of real money from the bank to the borrowers. And indeed, the money transferred became the borrowers, notwithstanding that they had a liability in restitution in the same amount. So, therefore, too, did the drawdowns under the intermediary loans and the new loans. The monies drawn down became the monies of the intermediary borrowers and the new borrowers. There's no material difference between any of the various loans, whether you're talking about the relevant loans, the intermediary loans, or the new loans. The only distinction is the relevant loans happen to be the ones that the bank has selected with their link indirectly to England and Wales. So similarly, the repayments that we rely on, they are just the reverse of the payments. Well, they start with transfer of funds, electronic transfer of funds to the intermediary and new borrowers, and then the transfer of funds from them to the relevant borrowers and then to the bank. They involve real transfers, just as the outward transactions on which the bank sues. Now, the same point applies to the crediting of the funds the bank received. to the borrowers, the crediting of the borrowers' accounts amounted to a choice by the bank to accept the funds in reduction of the borrower's liabilities, and that is what occurred. Now, the judge referred to our case at 1043, which I referred you to, but he then, the judgment meandered off and he never actually addressed the point. Now, the second point is that neither the bank nor the judge explain what happened to the payments if they weren't credited to the borrower's accounts. Where were they sitting? What happened to them? Once one recognises there were real transfers of money back to the bank could, as we know from Mr. Beketov's evidence, choose whether to apply them to the borrower's debts or to other liabilities. If it didn't choose to apply them to the borrower's liabilities, as we say it obviously did, what else did it do with them? No one has suggested any alternative analysis. It wasn't suggested, for instance, that the bank chose not to credit the monies to the relevant borrowers, but chose to credit the new borrowers. Now, the only sensible and coherent analysis is the one that we advanced, which was that the borrower's liabilities were repaid. And that is entirely consistent with Mr. Beketov's evidence and the passages I showed you from that. Now, Mr. Beketov didn't suggest that payment was not a real payment, or that the credit to the borrower was not a real credit, or anything of the sort. Now, we could have stopped there, looking at just the position on the bank's books. But as I said earlier this afternoon, we anticipated that we would have been met by a response, that we could not rely on the choice that had been made when the defendants were in charge of the bank to allocate the payments as repayments to the relevant drawdowns, when that choice was made by the defendants themselves. As it's put in my learned friend's skeleton, a fraudster's choice is no choice at all. So to preempt that argument, we went further, and what we said was that even on the assumption that the bank, now that it was no longer controlled by the defendants, could reverse the choice to credit the relevant borrowers, it had not done that. To the contrary, the bank post-nationalisation had decided to stick with the choice that had been made at the time of transformation, when the relevant loans were repaid. So the bank's books continued to record the relevant borrower's debts as repaid. That remained the position up to the trial and no doubt up to today. And there was no issue about that. Now, a point is made that we hadn't put matters that way in the pleading. Well, firstly, our case had always been that the relevant loans had been repaid, and I showed your lordship our pleading on that. But we, in fact, had said that the bank had always treated these relevant drawdowns as having been repaid. And that you'll see in the core bundle at page 843. In our defence. Now, admittedly, this is part of a pleading dealing with venire contrafactum, which is a principle relevant to whether or not the loans were void. But what you see pleaded as a fact is at 88. Accordingly, insofar as the bank's claim for loss caused by relevant drawdowns depends on a determination by the court that any of the relevant loans, intermediary loans or new loans were void or voidable and ought to be avoided, then the bank's claim cannot succeed. One, the bank has treated all of these loans as being valid as between itself and the counterparties as to the respective transactions, and has treated them as having been wholly or partially repaid in maintaining its accounts with those parties and for the purpose of compiling its financial statements. So it was clearly a pleaded fact, and that's what is important here, that the bank had at all times treated the relevant loans as repaid. And insofar as there was an issue about that, you'll see that in the supplementary bundle, or you'll see the extent of the issue in the supplementary bundle at page 84.2 in the bank's reply to this pleading at 24b.3 brackets 2, and what they pleaded was it's denied they've acted in bad faith and abused its rights, and or the venere contra factum proprium doctrine applies, if, which is not admitted, the bank has treated the relevant loans or intermediary loans as having been repaid in maintaining its account with those parties and for the purpose of compiling its financial statements. So the extent of the issue on this was a non-admission by the bank as to what it had done. Now, in fact, it's clear beyond argument that the bank has consistently and unequivocally treated the relevant drawdowns as repaid. Now, in our closing, which is in the supplementary bundle at page 172, at paragraphs 101 through to 114, we set out the evidence over 5 pages of what showed the bank consistently and deliberately treating the borrowers as discharged. And it's worth showing your lordships what Mr. Oleksienko, who was a member of the supervisory board, a very senior man, who came in following nationalisation, what he said about this. And his evidence was that the bank consciously and deliberately chose to treat the relevant loans as repaid. And you can see that in the supplementary bundle. If you would go to page 300 is where the transcript of day 11 starts, and at pages 301 and following, you have my cross-examination of Mr. Oleksienko, and you'll see on page 26 that line 4, I mean, he'd been cross-examined on something before, but I said, as we discussed yesterday, from the information in the media, the Our Money articles, the briefing and the audit documents, you knew about a large part of the loans to borrowers, the ones who are identified in this case, namely about 1.82 billion, and the associated sham supply contracts had been used, as you saw it, and were being told as a means of procuring, at an earlier stage, misappropriation of the bank's money by the former shareholders, correct? Yes, that's correct. And then I put to him that what you also knew as part of your becoming involved, in the course of October-November 2016, there's what's been called a transformation of the bank's loan book, by which 193 loans, which included the so-called, in these proceedings, relevant loans and other loans that had been used to repay them, the intermediary loans, had been repaid by the proceeds of loans provided to the 36 new borrowers, correct? Yes, that's correct. Sorry, I said loans. I should have said 193 borrowers. So as you understood it, I think you told us this yesterday, what you were being told was the effect of transformation that has occurred was the proceeds of new loans, which had been advanced to the 36 new borrowers, had been used to extinguish the liabilities of the 193 borrowers, and new and separate liabilities had been created and were owed by the 36 new borrowers. Correct? He said that's correct. And if you go to the foot of the page at line 22, the result of all of this at that stage was that the 193 loans, just at the foot of the page, the loans that were outstanding to the 193 borrowers prior to transformation, the position was that those had been repaid and the liabilities of the 193 had been extinguished. Yes, and this is right, isn't it? At all times since transformation, that is how the bank has regarded the position, namely the liabilities of the 193 borrowers have indeed been extinguished. Generally, yes, but I think we really need to look into it case-by-case situations. Right, sometimes collateral was discharged with mistakes, and that creates reasons for review of the termination. But generally, you're right. Well, generally, I'm right. Generally, is this right? Save insofar as there's been some mistake about collateral or something like that, having been misapplied, the position is, I think this must be right, the bank has not sought repayment from the 193 borrowers and has accepted that their liabilities were entirely extinguished by the repayments that were made out of the proceeds of the loans to the new 36 borrowers, correct? That's correct. Furthermore, the new borrowers, before nationalisation and immediately after, started to service the new loan agreement. Yes, and insofar as they service the new loan agreement, the bank, as it were, has accepted any money they paid and credited it to the account of that borrower, correct? That is correct. It's not to the account of the borrower, but as a service vis-à-vis the obligation of the borrower. I said that amounts to the same thing. So as far as the bank wasn't bound by the original decision to credit the relevant borrowers, it was entitled to remake that decision upon nationalisation. It had plainly and unarguably, we would suggest, chosen not to do that. And although the judge quoted a part of Mr. Oleksienko's evidence on this point at paragraph 1112 and correctly noted our reliance on that evidence, he never explained why he didn't regard it as sufficient to establish a choice to treat the relevant loans as repaid. It can only rationally be explained in our submission on the basis that this judge understood the choice that we were talking about to entail a decision to release tortious claims as opposed to a straightforward decision to treat the relevant loans as repaid. Of what? Yeah. Excuse me for a moment. I could just take you back to the passage that we were looking at a moment ago in Mr. Olishenko's evidence at supplementary bundle, page 302. Yes, and there's a further passage that on page 32, line 13, where I asked him, I understand the argument is going to have to be addressed in due course. What I'm focusing on at the moment, don't worry about arguing the case. I'm just trying to find out what in fact has happened and what the bank has in fact done. So I think this is right, isn't it? We've already agreed that at transformation, as far as the bank is concerned, the effect of it was that the liabilities of the 193 borrowers were extinguished by the payments that were made out of the proceeds of the loan to the 36 borrowers. And then you had liabilities owed by the 36. Correct. Yes, that's correct. Equally, insofar as relevant loans had been paid off, or sums in due from the borrowers in respect of relevant loans had been paid out of the proceeds of intermediary loans, the bank has at all times, both before nationalisation and after nationalisation, treated the relevant loans as having, the liabilities of the borrowers under the relevant loans, as having been extinguished. And he said, yes. So in our submission, the evidence really was very clear and unequivocal from the bank's witness itself. And as I say, the judge seems to have been proceeding on the basis that the choice that needed to be made was a choice to release the tort claims as opposed to a choice to treat the payments as discharging the restitutionary obligations. And Mr. Beketov had confirmed that if the bank chose to credit the relevant borrowers, that gave rise to a repayment. He said whether the bank had done that was a question of fact, not law, and it was clearly the case that the bank had, in its books, credited the relevant borrowers, and even if the bank could have, on the assumption it could have remade that choice after nationalisation, the fact is that the bank has at no stage sought to do that. Now, none of that is controversial. So one has to ask, well, why was it that the judge said we weren't even entitled to make the argument, which is what he did? And it's set out at 1091 to 1095. And in our submission, the judge here goes wrong. He says we needed to amend our pleadings and he wouldn't give us leave to amend. Now, there was no need for an amended pleading. Our case was still, as it has always been, repayments extinguished the borrower's liability and therefore also extinguished the loss in tort. The fact that there had been repayments was squarely pleaded throughout. Mr. Beketov gave evidence that whether there had been repayments, in fact, depended on the bank's choice in a void loan situation, whether the bank had made the choice to credit the borrowers. And all we were doing was pointing out that it wouldn't avail the bank to say the choice had been made in the defendant's era because, as we pointed out, the bank, had chosen to leave the position as it was and never, for whatever reason, sought to reopen any of their transactions. that was a perfectly legitimate point to make. And what's more, it was in fact a pleaded point, albeit in a different context. Now, at 1093 and 1094, the judge explained what he saw as the significance of the point not being pleaded. And he said that he accepted the bank's argument. It should have been pleaded because it gave rise to issues of Ukrainian law as to the legal basis for the case, the conduct relied on as amounting to a choice by reference to the knowledge required for choice to be free, how unequivocal the choice needed to be, and who would have been authorized to choose, and factual issues about the intentions of people involved. Now, in our submission, this was all wrong. None of these issues did or could arise. The Ukrainian lawyer, Mr. Beketov, had given evidence on the point. He was very clear that whether or not the bank made a choice to accept the payments as discharging the debt was simply a question of fact, or as he put it, definitely not a point for the Ukrainian law expert. And what you see is the judge at 1095 gets the matter confused, because at 1095 he says the bank also submitted that such evidence as there was as to what in fact happened was that nobody exercised a free choice to give up the claims it had started to investigate arising out of the misappropriation. This would have required a fully informed decision to accept wholly impaired loans to shell companies as compensation in place of compensation to which it would otherwise have been entitled as a result of the claims it was then investigating. This is a wholly improbable scenario, so that even if permission to amend had been sought, it wouldn't have been granted. And with respect, this is where the judge is going wrong. The only choice we suggest that was necessary was a choice to credit the payments the bank had received to the relevant borrowers. We weren't advancing a case or argument that the bank had made a choice to give up claims or a choice to accept wholly impaired loans as compensation in place of the compensation to which it otherwise would have been entitled. Our case was a far simpler.
I think we've got that point sufficient.
Yeah.
I'm afraid we do need to stop
Yes,
there for today. Can I just quickly inquire how you're doing time-wise generally? Do we need to start at 10 o'clock on Thursday, or would it suffice to start at 10:30?
I mean, I have to say a little bit more on this particular topic, and then one more topic, which is asset transfers. I think we were anticipating in devising the timetable that we were starting at 10 o'clock today and on Thursday, and then at 11 o'clock on Friday. I don't know whether
It's still 11 on Friday.
So in that event, unless it's too inconvenient, can I ask if we do sit at 10 o'clock on Thursday?
All right, we'll do that.
I'm grateful.
And we'll pause until then.
Well,